Your mentor Kuber is also joining money. And we have another mentor, Annapurna Tabdaman is also there. We can start the session, ma'am.
Thank you. So, good morning, all of you. Today being the first year of the financial year, I greet all of you with prosperity, profitability, and grand financial year. So, with this, the topic allotted to me for today's discussion is principle of mutuality, how it evolved, challenges that the doctrine went through over the last 150 years, and currently, what are the litigations that we are facing under GST? So this is what I'm asked to cover in the next 1 hour of time. So first, let us understand what is the doctrine of mutuality, because this is a very well-known concept to all of us, but still, this is a concept which has come from the common law. So it is not a codified or a positive law where we can refer it from any of the statutes. First, that we have to understand. So when I say common law, it is coming from the Britishers, because we were ruled by Britishers for many years. So many of the statutes that we adopt are from the colonial system, from the Britishers. Same way, even India is also part of the Commonwealth nations. Some of the nations, if you look at worldwide, some of the nations, majority of the nations, I would say, follow the common law and the positive law. Whereas some of the European countries, they strictly follow only the positive law. So when I say common law, it is not codified, it is not written anywhere. So it is evolved over a period of time. And the principles are coming out or emerges from the judges, like, when it goes to the court, the principles are taken to the court from the tribunal or from the appellate authority or whatever, from the judicial forum, it goes to the high court or Supreme Court. From there, whatever the judge decides based on the principle of equity, the law crystallizes. So this is one such doctrine is doctrine of mutuality. So when I say doctrine of mutuality, the concept is like this. When there are many members joined together, say a group of people joined together for a common objective, pool some funds, pool some money for some common purpose, and spend it for their own betterment and interest. So there is no profit element. It is just more like a reimbursement. So the question before the authorities were, when there is no objective of profit, there is no commerciality involved in this, should there be a taxation? So tax should be applied on this concept of mutuality. So this is what the law which is being debated over the 150 years. So this principle emerged from the 18th century. Now we are in 2025. Almost about 150 years, we are still debating on the simple concept of doctrine of mutuality. So in family, we say that every penny saved is penny earned. But when it comes to taxation, the authorities do not want to look at it that way. Even every penny saved, that means the surplus that you get should also be taxed. This is what the thought of revenue. And when you say that you are a family, there is something called as relationship. There is nothing called as profit motive. Say, for example, when I make some food to my son, I do not expect anything from him, because me and the son are same. There is no furtherance of business or anything of that sort. But still, if statute wants, they can always tax it. Considering, so this is one part of the discussion. The other part is that, but the relationship, affection, and then whatever I serve cannot be brought to tax is the another part of the discussion. So when I say taxation, concept of doctrine of mutuality, there should be two distinct persons for any statute to tax. Whereas in the case of mutuality concept, the members or the friends or the group of people and the person who elects, say for example, if I have to give you an illustration, let us take the case of Resident Welfare Association. where all the people are the members of the association. Among them, they decide 5 or 6 group of people, members will be elected as agents to represent the members. So when I say the agent and principal, the agent acts on behalf of the member, but they are also members only. It means that members, it means that the association is represented by members. So association becomes the subset of members. So there is no.
Sujata madam.
Yes,
Please,
yes.
sorry to interrupt. Are you sharing presentation? If yes, we are not able to see it.
Not
We
able
are seeing your that folder, the doctrine of mutuality.
folder only. I have opened it now. So, okay, I'll stop share and present again. Now you are able to see.
Yes.
So, there should be 2 distinct persons. When I say Resident Welfare Association, the members, the association is also represented by set of members. So association becomes a subset of the members. So, and one more important point which we have to keep in mind when it comes to the doctrine of mutuality is that no man can profit from himself. So when the association or club or whatever it may be, when the members act on behalf of, that is a group of people, core members act on behalf of the other members, they do not intend to make any profit. So they work for themselves, they serve for themselves. So there is profit element is missing. So this is the basic concept of mutuality. This is driven from the common law. So when I say common law, first and foremost, we have to take the guiding principles or precedents from the English court. Venu, you want to say something? Your hand.
I just want to ask a question. Can I interrupt now or at the end?
Anytime is okay.
Previous slide.
Yes.
So we are saying that no man can profit from himself. Now, the RWA is one association. Now we have association like KSCA also. Even that would fit into this.
Whenever you are pooling common money, see, that is what, just because it is an association, we have to see the underlying transaction. If money is collected from members and it is spent towards members, then the concept of mutuality comes in place. So when I say KSCA, yes, it is collecting from members and non-members.
If KSCA collects only from members.
Only from members and it is spent only for the purpose of members, then it is a concept of mutuality definitely exists.
And any surplus that it makes will not be liable for income tax.
That's a different question, because now I'll come to that part. How it is treated in income tax, how it is treated under sales tax and GST are 2 different parts to the discussion.
Now, because we are making a statement that you cannot make a profit from yourself.
Correct.
So that means the surplus will not be treated as profit.
Not necessarily, because income tax looks at it in a different angle.
Okay. So then the statement no man can profit from himself is originating
from the English law. No man can profit from himself. That means if you want to tax anything, you need to have 2 distinct persons.
Okay.
I cannot sell it to
association is not distinct from the members.
Association is not distinct from members. Correct.
Okay.
Good. So when it comes to the Court of England, we will first understand how the common law was treating it in the judicial precedents. Jurisprudence came from common law. So let us understand some of the decisions that were handled in the English court. So basically, the reason why this concept was tested and put to trial by the English high courts were that many people were taking shelter under the concept of mutuality, and there was some kind of tax evasion, right? So to avoid that, the only way for the revenue to prevent tax evasion and leakage of revenue is that to put it to trial. So they have to say that, yes, this is subject to tax. Then it is for the taxpayer to prove that it is not taxable. Then go to the higher court. Finally, the Supreme Court will decide, saying that understanding the complete nature of transaction, it will decide that, yes, this transaction comes under the concept of mutuality. So it is always for the revenue to disprove that this transaction is a, does not fall under the concept of mutuality. So when I say in the English courts, the first in the 18th century, I think in 1850s, there was a first case, Dublin Corporation versus Magdam. This is a case of income tax, wherein the water corporation was collecting tax from its members, and then there was a surplus. There was a surplus out of the collection after spending. So there was a question before the authority whether the surplus is subject to income tax or not. The courts held that the surplus should not be subject to tax, because no man, in my opinion, this is made by judge, because this common law doctrine, any doctrine for that matter, is evolved from the statement of the judges. So I'm just repeating, no man, in my opinion, can trade with himself. He cannot, in my opinion, make it what its true sense or meaning, taxable profit, by dealing with himself. So it was held that Dublin Corporation, though it has some surplus, it cannot make profit from himself. So it should not be subjected to income tax. This was the decision which was held in the English High Courts. So when it comes to indirect tax, that is sales tax, the Graf versus Evan is the famous case law. It's a landmark decision. There also it was a club where the members contributed for the for the enjoyment and refreshment of their for their own refreshments. Later, the one person among the members will pool the money and spend it for their own benefit. There also it was held that there are no two distinct persons. There is a concept of mutuality prevails. So this should also be not subjected to sales tax. So from the English court, we are very clear that it is income tax is also not applicable, and service tax, sales tax also not applicable. Then when it comes to India, these are all in 18th centuries. Now when I say in India, the first decision came in the year 1957. That is 1957 is just after our constitution was born. So in that case, what happened? Similar clubs were transacted in transactions were held in India also. The Bengal Nagpur Cotton Mills Club versus Sales Tax Officer is the first case, where the facts of the case being the Bengal Nagpur Cotton Mills is a social and recreational club. This objective was to entertain members. Same way it was collecting the money from its members and it was spending it. Notice was reserved by the sales tax authority stating why the registration was not taken by the club. So then the argument placed before the authorities was that if you look at the definition of dealer, how we see the definition of person, if you look at the Sales Tax Act of Bengal, dealer included the clubs, right? It means that the statute, the sales tax wanted to include the dealer, the club as a dealer, and it thought that if you include the person, like the dealer club as under the definition of dealer, it is a person, and where there are transactions happening between the members and the club, there is a sale is happening, so it will fulfill the conditions of sale, so it can collect tax. So that was the premise under which the notice was served to the club, why you have not done the registration. Whereas the court held that there are no two distinct persons, there is an element of sale is missing in the transaction, so it cannot be held to be a taxable transaction. So registration is not required in this case. So from this, what we understand from 1957 is that the concept of mutuality prevailed in 1957. So the concept of the doctrine override the principle, whatever was stated in the statute. Then next case was that if you come to income tax, I'll come to your questions, Venu's question. In income tax also, if you look at it, section 247, it clearly says in the definition of income, it includes, concept of mutuality is not restricted to clubs or association. It can also be extended to, say, insurance companies or banking companies or chit fund or any sort of those kind of self-help groups and other stuff. Whereas if you look at income tax, they have very clearly, narrowed the principle. And from beginning, from 1961, we are talking about 1957 now. In 1961, soon after the Income Tax Act was enacted, they clearly brought in this definition of income and included the cooperative societies and the banking and insurance companies under the definition of income itself. It means that the statute gave the provision that the taxable income, the whatever surplus or profit that is derived out of those, the mutual associations or cooperative societies or whatever it may be, are all subjected to income tax. So it was fit into the act itself, in the definition itself. So we are not discussing about income tax. Now, when it comes to the sales tax, in sales tax, the element of two distinct person was absent. And the transaction, when they went through also, the court, when it understood the underlying transaction, the element of, forget about profit, I'm not talking about profit, the element of sale, the essential ingredient of a sale was missing. So the court held that this transaction fits into the definition of concept of mutuality, so it is not a sale. Second, this was a high court decision. Whatever that Bengal cotton mill was a high court decision. Then I'm taking you through the another Supreme Court decision where in the case of Young Men's India Association in the year 1970, that is also again a club, again collection of members, the funds were collected from the members and it was spent for the purpose of members. And then the issue brought before the authorities was that a supply of various preparations by each club to its members involved a transaction of sale, whether the transaction is coming under the definition of sale. Then the petitioner argued that, yes, there are four main ingredients to a sale. One is that there should be some party, just like any other contract. There should be a contract, there should be a concern, there should be an offer, there should be a consideration. Only if all these things are fulfilled, then it becomes a contract. So same way here also, it fulfills all the condition, excepting that there are two distinct members. That means one buyer and seller, or one service provider and service recipient. There are no two distinct persons are involved in the transaction. So the court looked at the transaction and then proved that, yes, the Young Men's India Association, in this case, the concept of mutuality prevails. So the transaction between the club and members should not be subject to sales tax. So this was the decision held in the year 1970. So from 70 onwards, there were various decisions. The court will say that High Court will, in various states, I'm talking about the sales tax, right? So sales tax means every state will have its own act. So every taxpayer will have to go to the High Court and prove that it is a concept of mutuality. So there are a lot of litigations from 1970 to 1980s. So in that period, then the government, the Law Commission proposed that, what is it missing? Like, why are we struggling like this? Why can't it be fixed through the act? Why can't we have a sales tax act which covers comprehensively all this, right? The reason why I'm discussing here is that you can draw parallel line with our GST, right? In sales tax also, this attempt was made in the year 1970 itself. 1970 itself, this was done, saying that in the dealer definition, they included clubs. In the four elements of sale also, they included artificially, they introduced a deeming fiction. And then they said that there are two persons, the person can be a member or club or whatever it is. All these things were fit into the statute, but still it failed. The Young Men Indian Club, Indian Association decision stood for a long time. And various other courts in different states of India followed that decision as a precedence. And then it was proved that concept of mutuality prevailed over the respective states' sales tax act. So none of them could, catch hold of these kind of associations or clubs saying that there is a profit element, or even if they made a profit element was not the criteria for making it as a concept of mutuality. They were looking at only the transaction. So when the transaction itself, the basic transaction itself failed, considering the basic contract act itself failed, and the sales tax also failed. So there was no transaction, there was no sales in the transaction. So it failed the test of test of sales with the respective state laws. So because of that, they felt that there is some lacuna in our system. It means that if you want to comprehensively include all these definitions, it has to be incorporated through the constitutional amendment. So at that point of time, 1970s, if you look at the list 2 of entry 54, it had a very, very simple definition to include sale: taxes on sale or purchase of goods other than newspaper, subject to the provisions of entry 92A of list 1. If you look at this definition, it goes back. We have Article 265, which states that no person can collect tax other than the other than the enactment of law, right? So unless and until you have a statute, the tax cannot be collected. So entry 54 was referring to the taxes on sale. It means that you directly have to go to the respective state act. So if you want to tax any transaction, the only way that was boiling down to the respective state's sales tax act. In the sales tax act, whatever you do, the concept of mutuality was prevailing over because of the Young Men's Association Club. So most of the transactions failed. The revenue could not do anything. So what the government decided in the 61st Law Commission, they recommended that there should be some amendment in the constitutional provisions with respect to entry 54. So they suggested, why they suggested? They said India's constitution, that means before constitution itself, the Sales Tax Act was there. It did not expect, see, the law is evolving over a period of time. So new transactions are coming. If you look at even today, the OIDR services is something new. Cross-border transactions are new. Similarly, over a period of 150 years, the trade is also evolving. So when the trade is evolving, the law should also evolve. Whereas the law was behind. So they felt that there is a necessity for us to change the constitutional provisions, because unless and until you amend the constitutional provisions, the respective states cannot amend the law, amend the act. Otherwise, what will happen? One state will follow some act, other state will not include. So it will create chaotic situation for in terms of sales tax. So that is the reason why, if you look at it now, GST is introduced. Whereas in GST, ideally in 1982 itself, if they have brought in GST, this problem would have been solved. But in 1982, there was no service. There was no concept of service. Nobody was heard of service, and only sales tax was there. So respective sales tax were prevailing. So to put a full stop to this problem, what they did, they introduced, the Law Commission recommended Article 366(29)(a), through which they included certain transactions, because over a period of time, they realized that there are certain transactions necessarily to be taxed. The only way to include such a transaction is to bring in the amendment in the constitution. So what they did, they introduced certain things, certain 6 points they introduced. They identified 6 issues. First, let us understand. They identified 6 issues, 6 lacuna in the Sales Tax Act. One was that whenever there is, we know that for any transaction to go through or any contract to fulfill, there should be a free consent, offer and acceptance should be there. What happens if there is no acceptance? Say, for example, through operation of law, if I acquire a company or government acquires a company, in such case, should there not be any tax? That test also failed because Sales Tax Act did not cover that point. Second, whenever there was a works contracting where material and service element was involved, the taxpayer started doing bifurcating sales majority of portion and material as very less element, so that they can avoid tax. The government was aware of it, but nothing could be done because the Sales Tax Act was taxing only on the goods. This also had to be plugged in. Then hire purchase. If you look at the hire purchase contract, like every month we pay the hire purchaser will month on month he will be paying towards the hire purchase agreement. Towards the end of the term, at a WDV value, he will be buying it. So the taxation was at the WDV value towards the end of the term, through which also the revenue was, there was a lesser collection of revenue because of this hire purchase agreement. Then next was that leasing of film. So instead of selling the film reels, they were leasing it. Like, A will lease it to B, B will lease it to C, so that after 10 years, it will have nil value. The film will not sell. So at that point, they used to pay very less tax and they were avoiding the tax. So this transaction was also, the government was losing huge money. Next is the clubs and associations, the concept of mutuality. Finally, the supply of food as part of service. If you look at it, if you go to a restaurant, yes, you paid, you eat. While eating, the sales tax was collected. But when they were staying in a hotel, in a star hotel, when they were ordering food, the sales the authorities could not collect on the entire amount because it was going as a lodging services. So through which the food services were getting escaped, that the transaction was not liable to be taxed. So irrespective of whether the person eats in the restaurant or sits in the lodge and sits in a room and eats, the transaction should be ideally covered. But the law did not enable such a transaction. So that was also missing out. So the Law Commission felt that there are few transactions which were escaping out of the tax bracket should necessarily be covered under the constitutional amendment. That's the reason why they introduced Article 366(29)(a), A, B, C, D, E, 6, E, and I think F also was in. 6 clauses were introduced. That E was covering the clubs and association. So when I say A, B, C, D, E, all these things were all the A to F were introduced only after Supreme Court judgment. It went up to the Supreme Court, then they realized that, okay, this was missing, then let us introduce. So these are all the case laws which I have quoted here. One such example is the Gannon-Dunkerley case, which is a very dominant intention theory on works contract, which we all know. So some of the cases were very landmark decisions, A.V. Mayappan case also. So these are all the cases which went to the High Court, Supreme Court. Young Men's Indian Club also, one of such a very famous case law through which the amendment was done in the Constitution. So because of that amendment, they could boldly say that, yes, from these principles, we are this transaction is getting taxed or not getting taxed. So, so this is what is about. Then this happened in 1982. So from 70 to 1982, the principle of mutuality prevailed, relying on the decision of Young Men's India Club. Then came in 1982 to fix that, to overrule that decision. Through the recommendation of the Law Commission, they made an amendment, 46th constitutional amendment, through Article 366(29)(a) was inserted. Because of this insertion, the government believed that the concept of mutuality can be dusted, can be done and dusted. Nobody will knock the doors of High Court saying that this principle prevailed, because it is there in the constitutional provision. If you read that constitutional provision, tax on sale or purchase of goods, tax on supply of goods by an unincorporated association or body of person to a member thereof for cash, deferred payment or other valuable consideration. It clearly covers goods and unincorporated association, body of persons, cash or deferred payment or other valuable consideration. So government thought that this covers the transaction of whatever, concept of mutuality is also well within the ambit of this 366(29)(a, right? Whereas after the constitutional amendment also, Calcutta Club in the year 2002 it started, right? In 2002, the Calcutta Club started. Even much prior to Calcutta Club, there were Ranchi Club, Cosmopolitan Club. There were so many clubs went to High Court level. They proved that concept of mutuality prevails over the constitutional provision. And then this Calcutta Club took the lead in the year 2002, and then they defended the case. Similar facts are the same, more or less the same. I don't want to go into the facts of the case. Same club, same collection of members, but it was a sales tax, and service tax also came in 1995, I think. So service element was also involved. So the issues placed before the authorities in the case of famous Calcutta Club was that whether doctrine of mutuality still prevails even after the 46th Amendment, because the 46th Amendment clearly clarified that this is going to be included. So even after that, why should we refer to the concept of mutuality? So does it still prevail? That was a question number one. Then second was that when we are after making the amendment, is it applicable only for incorporated or unincorporated club? Does it make any difference? Then third was that food and beverages by incorporated clubs to their permanent members constitute sale, thereby holding the same to be liable. Sales tax, sales tax is applicable on those transactions. So these three: one, doctrine of mutuality; second, whether the post amendment also does it prevail; third was that sale transaction, sales tax, is it applicable on this transaction? So these three questions needed to be answered by the Supreme Court in the case of Calcutta Club. Then the revenue argued that point of revenue was that, contention of revenue was that even after the 46th Amendment, the concept of the Young Men's Club will not hold good, because please forget about Young Men's Club, because 46th Amendment will overrule all that. So please refer to only 46th Amendment, which very much covers the unincorporated clubs. If it is an incorporated club, you don't have to bother, because the member and the institution are two distinct entities. They were taking the reference of a company. Say there is a company, there is a shareholder. Company and shareholder are not one and the same. So when you have incorporated your club as a company, like, Section 25 companies as per 1956 Act, Companies Act. So when you have incorporated your club as a company, Section 25 company, so the company and members are two distinct persons. So the constitutional provision covers the unincorporated institutions or entities. It means that whether you are incorporated or unincorporated, it is very well within the ambit of constitutional provisions. So forget about Young Men India's Club. Don't bring it here. This was the contention of revenue. Then the supply of food and drink by the clubs, same thing, 366(29)(a) would be applicable. So the concept of doctrine of mutuality will not prevail over the constitutional provision. This was the one stand taken by the revenue. Whereas the assessee was continuously harping on nothing doing, whatever may be the constitutional provision. The equity, the principle of equity or trust or agency model cannot overrule by your constitutional provision. So they were continuously saying that concept of mutuality will prevail over any other constitutional provision. So they were arguing on that matter. And service tax, as far as service tax is concerned, the mutuality principle is applicable to services also. Though it covers only sales tax, it can be extended to services also. And the service tax definition, if you look at it, the clubs and association, I would like to take a pause here, because I may be wrong, because in 2012, as per my understanding, up to 2012, the Service Tax Act, the definition did not cover unincorporated clubs. And after 2012, that some negative list was introduced through which some incorporated clubs were introduced. So because of that, in both the cases, service tax got escaped in the through the concept of mutuality. So somebody can clarify on this. Because of this, the service tax element was absent because of the concept of mutuality, whether it is an incorporated club or unincorporated club, was the argument placed before the Supreme Court by the assessee. So the court held that they analyzed the transaction. Then they said that supply of goods or services, whether it is incorporated or unincorporated, club or association to their member, would not be exigible to sales tax or service tax. This was the final judgment in the Calcutta Club case. So it was proved that concept of mutuality will prevail over any other constitutional amendment. And they even taken from the act itself, from the statute itself, how the concept of mutuality will prevail over the, the service tax, prior to 2012 and post 2012 up to 2017. So till 2017, the case law that we have on concept of mutuality, Supreme Court judgment was Calcutta Club case. We may ask the question, why do we have to refer only the Supreme Court case? Because as I mentioned earlier, this doctrine, any doctrine for that matter, as the matter evolves, the latest one will prevail. So as on 2017, this judgment came in sometime in 2019, September or October. So till 2019, it started in 2002 to 2019, almost for 15, 17 years. So till such time, the Calcutta Club decision was the precedence for the concept of doctrine of mutuality. So even today, in 2025 also, the Calcutta Club is our precedence for a concept of mutuality. Now came the 2017, GST was introduced. When I have to say in GST, same story. It is, I don't find, when I read that previous decisions, I am not able to, find any difference. Here also artificially they wanted to tax, because the intention of the lawmaker was that they wanted to include these transactions under the ambit of tax. They wanted to charge tax. So what they did in the definition of person, 284, they included club. And in the business also 217, they said, yes, the transaction, whether you do it occasionally or whatever it is, provision by a club or association or society of facilities to the benefits to its members will also be considered as a business. So included in the definition of person, included in the definition of business, and in the supply also, if you look at it, all forms of supply, right, made or agreed for a consideration. There was a consideration by a person in the course or furtherance of business. So there is a business element. Business is included in the clubs are included in the definition of business. So they were linking, but they forgot the fact that by a person is there, but to a person, two distinct persons were absent. But still, for all practical purpose and our understanding, we can always say that by a person is to a person, though it is not explicitly stated, we can always assume that to a person was absent in the definition, but to a person was present. So whether the member and the club were different or not, for the limited understanding, when you read the law as it is, you don't have to break your head. So for the simple understanding of the law as a law abiding citizen of if you take the example of a club, by going through all the definitions, it was very much covered. The club or association was very much covered within the definition of business, person, supply, and consideration was present. So very much it was taxable. Then came 2019, this decision, Calcutta Club. This is in the year 2017. 2019, the Calcutta Club decision came where it said that service tax, service tax is not applicable because doctrine of mutuality will prevail over the constitutional provision, because the constitutional provision was untouched. It was as it is. To our surprise, what they did, 366(29)(a) clause E, subclause E was borrowed into the schedule 2, clause 7. They directly picked and then pasted in the schedule 2. So what they thought that by borrowing it from the constitution and pasting it here, it will fix all the problems. But they never realized that this Calcutta Club will create a issue and it may litigate. The taxpayer will go into the litigation mode because of this absence of this, two distinct persons. So what they did, it was analyzed. If you look at the GST Council meetings, first thing what they did, I'm picking the example of a resident welfare association. Through notification 12, the law was as it is. Let us forget about the law for a minute. The law was there. Through notification number 12, they created an exemption up to 5,000. Then later it was amended to 7,500. And they were saying flyers were introduced. Flyers were circulated by the department CBAC, and FAQ was circulated saying that the concept of mutuality does not exist in the new law, because that's an old service tax. That applicable decisions were all in the service tax. This is a new law. So concept of mutuality is not applicable. So member and the association are two distinct persons. They were artificially creating, and then flyers were circulated. And all the advance rulings were also in favor of revenue, saying that subscription or monthly maintenance charges or common area maintenance, whatever the association collects beyond certain threshold limit, it was subjected to GST. This was the ruling which was given by all advanced ruling authorities, and circulars were also issued saying up to means what. There were so many circulars were also issued. Then they realized after Calcutta Club, in the GST Council meeting, they felt that the taxpayer may litigate, may challenge this provision, challenge this circular, so that we have to quickly do something about this act. So this decision happened in 37th GST Council meeting. They were very well known. All the ministers and the finance minister in the open discussion, they realized that we made some mistake while drafting the law. So what they did, but they could not do immediately, because this happened in 2019 when the judgment came in that meeting, 37th GST Council meeting. Then in the 39th GST Council meeting, what they did, they introduced, they discussed about the Calcutta Club. Then they realized that if you make a express provision in the act, okay, if you make an express provision in the act, clearly saying that this transaction covers taxable, is subject to taxable, you create a deeming fiction, expressly state that cover the transaction with the constitutional backing, it can be subjected to tax. So nobody can evade tax if you put it in the act itself. So what they did in the 2021 finance bill, they introduced this provision with retrospective amendment. From 1st July 2017, from the day of inception of GST, this provision will be applicable. They introduced backward and then they regularized it. So this is what made to the insertion of section 7(1)AA. If you look at 7(1)AA, so this is the, I have captured the points from 37th GST Council meeting. And if you look at the 7(1)AA, they omitted all the provisions of 7(1)D, and then schedule 2, serial number 7 was also omitted. Then they inserted saying the activities or transaction by a person other than an individual to its members or constituents or vice versa for cash or deferred payment or other valuable consideration. So this was introduced in the year 2021 Finance Act with the explanation that for the purpose of this class, it is hereby clarified that notwithstanding anything contained in any other law for the time being in force or any judgment, decree or order of any court, tribunal or authority, the person and its members or constituents shall be deemed to be two separate persons, and the supply of activities or transaction inter se shall be deemed to take place from one such person to the other. If you look at it, whatever, they had missed out in sales tax in 1956 and then in service tax, and after the Calcutta Club judgment, they have fixed everything through section 7(1)AA and made it retrospective. It is not even retrospective, it is called as retroactive. So with this, we can say that to the best possible extent, GST has made a full stop to this concept of doctrine of mutuality, so that nobody can go to the court and say that this doctrine is applicable. Hello? This doctrine is applicable, so that it will not be subjected to GST. Then comes to the question of, now the point before all of us here is that whether this section 7(1)AA by insertion, whether it has made a full stop to this problem, or can we continue to say that our constitution cannot override the principle of equity and common law will still prevail. So concept of mutuality will still prevail. Can we go on saying that, or should we accept that GST is applicable on the transactions between members and the club? Is the question. I am placing it before you. So before I conclude, maybe I will give
Madam,
my,
before getting into that question,
yes, sir.
we can also draw views from the
Yes, yeah,
numbers here.
yeah.
Whether 7,188 was actually required, what was the missing provisions earlier
Hmm.
in the GST statute that this amendment is filling up? Was it not taxable earlier prior to this amendment?
So my group leader's question is that even
You
without
can express
introduction
your
of,
views, madam,
huh,
and
so
then we can have views from.
7(1)(a), without even introduction of 7(1)(a), was that not covered under GST, correct? Was there explicit
Yes,
provision
yes.
needed? Was there any explicit provision needed under 7(1)(a)? In my personal view, you don't have to go, there is no need for introduction of 7(1)(a). Even without that, it very much covers, but still they wanted to introduce, because if you look at the 7(1)(a), to a person was missing. It says by a person to a person. Okay, that means that there should be two distinct person. If you do not have two distinct person, it has to be explicitly stated. If you do not explicitly state it, like Schedule 1, deeming fiction, tomorrow somebody else will say that yes, it is not, covered. So again, that problem will come. Members and club are not too distinct, or one and the same.
That deeming fiction was already existing in section 2, subsection 84, no?
Section 284, it did not exist, no? It says
So-
association of person or body of individuals.
No, if you go to 284,
Correct.
it says individual, it also includes
Correct.
companies,
Correct.
it also includes association of persons, cooperative society, all these things.
Correct.
This deeming fiction was existing then also.
Person was covered, but transaction between two persons can happen. Any transaction can happen only between two persons.
No. When the law is identifying individual and also association of persons,
Correct.
two separate persons, then I think deeming fiction was existing then.
We can take it that way, but still the litigation was open.
I think Venu has some
Question.
points to mention.
Yes.
Madam, so the act made this as retrospective amendment, 7(1)AA, right?
Retroactive.
Yeah, which means my view, okay, is they sensed that this was not covering. Like Kuber's question was, this got introduced in Finance Act 21. That means prior to that, was it something escaping? I think prior to this, something was escaping, so they made it retrospective amendment. And 284, the person included the clubs and association. In 7(1)AA, you are stressing upon the word like by a person, and which is the 2AA to its members. Now, isn't it specifically when you see the section 7, which is the charging section, the scope of the supply? It is definitely the activities which have been listed in the 7(1)A by a person. So the person was definitely covered in 284. So 7(1)A was covered, and you are saying that 7(1)AA is not required because 7(1)A includes by a person. But 7(1)AA is the by a person is there, but to its members. Now, this is specifically maybe to ensure the Calcutta Club, bringing the difference between the person and the members of the person. Because under GST, the moment you have a separate GST number, the levy is there from one GST to another GST. That means you are making a profit on your own transaction, so that itself is covered. So I still feel something was missing, which made sure it is not just to cover themselves from the Calcutta Club case, but definitely I see there is a lacuna and they want to fix it and they brought it, is my view.
So what was missing is the question here, because from where we are looking at the law and the provisions, 284 person covers individual and also association of person. And there is supply provision section 7 subsection 1. There is schedule 1. So when you read all these provisions together, we can draw a conclusion that, okay, this was anyway part of the statute prior to amendment, and the transaction between the members and the club or association of persons was anyway taxable. I am not saying any missing provisions prior to amendment. Maybe other members can.
Yeah, the floor is open. Others can please add. See, was there a necessity for introduction of 7(1) AA? Even before introduction of that, whether, the transaction was very well covered
Yeah.
under
The
section 7(1).
Schedule 1, it clearly says any transaction between the distinct person is a supply.
Distinct.
Yeah, distinct person is a supply. But members and association, whether they are deeming friction to say that both are different was missing.
Related party under section 15.
Correct. Related party, but related party, whether one and members and association and the members, are they same or distinct? Because we cannot say they are a distinct and related party, but there should be some deeming friction to say both are different, because the common laws assumes that both are same, one and the same.
Now, Miller, that I think that's what when you go through this section 284.
So 284 says persons. See,
Person,
in the sales tax
individual
also we
and
had
also
person
association of
definition.
person.
Yeah, in the sales tax also we had a same definition. There also they said cooperative societies and everything is a different persons. But the what was lacking is the deeming friction to say both are different was the thing which has to be looked into. Because person definition was same in the income tax, service tax, VAT, both. But in spite of that, courts are held that the deeming friction was missing to say that both are different.
I agree with this Mylar point actually. One thing is, I think they brought it to overcome the Calcutta judgment, because if you see the time of amendment and the time when that judgment was there, that is a one reason. And second thing is, this deeming fiction was there from the time the constitutional amendment was made in 3629A, and which you are referring by sales tax. All that entries of works contract, all these entries of this club and association, they brought by a concept of called as a deemed sale. Actually, there was no as such a sale, but they introduced by way of deemed sale. So that was continued in the sales tax. But as you have already shared that in service tax, the definition itself has excluded the principle, this doctrine of mutuality. And based on that, there was an argument, if you see in the Calcutta Club also, on the basis of unincorporated association and incorporated association. So all this looking into the factors, I believe that this explanation, whatever is given in 711A, that is only to overcome the judgments, because that has ruled on the doctrine of principle, doctrine of mutuality, whether it is a Youngman Association case or Calcutta Club case. But only one thing I can say, that the definition of person also is not talking on to its members. If you read strictly the definition, it is only talking on the services of club or association. It is not talking to whom, to what. So still the principle of mutuality was prevailing. So to overcome that, to make a clarification on the deeming friction, I think this explanation is added. But I think this explanation will also get challenged, because they cannot bring out saying that you cannot follow the judgment, court, tribunal, authority. So you cannot bring out something kind of an explanation saying that that will not have any force in the law. That is what I can understand with that. And they're also trying to bring out deeming fiction by way of explanation that they are deemed to be two separate persons, though it is not a two-person, because when you are talking on mutuality, the club and its member is one and the same. But if you see the explanation, by deeming fiction, they are trying to bring out by overcoming that judgment. So I still believe that to bring out a clarity in the section 284 and specific section they are brought by 71AA. That is my view. Otherwise,
What
most
basis
of us
you
are
use?
following Calcutta Club only. still today also, even if we apply the principle of Calcutta Club, I think till 2019, till that ruling was pronounced, many club have not paid the service tax as such because they are still believed on the doctrine of mutuality. I think that has overruled that. To overcome that, the 71AA has been introduced.
Annapadam, on
Yeah.
what basis you said it can be challenged?
No, why? What I'm saying is, if you read the explanation, I'm not saying on 71AA, but if you see
Okay.
the explanation, it says that notwithstanding anything contained in any other law. See, you cannot bring
Correct.
out something as an explanation by overriding the principles of the law, which are already placed by the law, Honorable Supreme Court. And you cannot say that notwithstanding anything contained in any other law for the time being in force. Then also they are trying to bring out any judgment, decree, or order of any court, tribunal, or authority. The person and its members or constitution shall be deemed to be so that is what I believe, that to this extent it can get challenged. This is what I'm trying to say.
But what I'm
And
saying, madam, see, whenever there is a deeming friction, it is they are deeming that to overcome the common law.
yeah,
And they
let
say
them come out.
notwithstanding anything, any other law or any other
Uh,
common law. So for the purpose of GST, we want this two to be a deeming friction. But I don't see, because
no, but
notwithstanding anything,
see,
they
they would
want
have
to
brought
deem.
it. I'll just tell you, the concept of declared service was there in service tax. The concept of deemed supply was there in sales tax. They amended the definition of sale itself by bringing into a deemed sale. They did not override the provisions of the other law, right? Because whatever has been brought out within the definition of sale or definition of service, it was very much included. So here also, without referring to the other law, they would have directly post out that yes, there are two separate persons and the activity is called as a deemed supply or whatever it is. But they cannot bring out saying that notwithstanding any, still the principle remains the same now. It is not that it cannot remains the same. The principles of mutuality will still remains the same. That is what I'm just trying to bring out.
It will remain the same, but for the purpose of this thing, it will not override. They wanted to deem it.
I feel that they would have brought out saying that the person and its members shall be deemed to be two separate persons, and the
Correct.
supply of activities shall be deemed. That was sufficing for the bringing out deeming fiction in the concept of supply. They need not bring out saying that notwithstanding anything contained in any other law for the time being. Because the GST law is not executed independently. It has to go with the allied laws principles. We are applying Sale of Goods Act. We are applying Contract Act. So all this will prevail. You cannot just say that it cannot prevail. That was my thought process on this explanation. And I think, Sujata, you have covered that Bangalore Turf Club, this case also later, you are covering that.
No, I have not covered. I have taken only Calcutta Club and Young Men's Indian.
Okay.
So in my view, by
And,
making it, by inserting
Sujata, 1 second, 1 minute. Sujata, one more point. If you see here, they are trying to bring out it is hereby clarified. So something it is giving only for a purpose of clarification.
Clarification, correct. Correct. See, if you look at it now, like Calcutta Club decision definitely shattered the GST Council because it is very well discussed in 37 and 39th. Only after that they have brought in the retrospective amendment. They also realized that there was a lacuna in this course. By was missing, to a person was missing, by a person only is there, two distinct person was not there. And one more thing was that this association of person, I could not find any definition anywhere. What is AOP? Nowhere defined. Okay. So again, people will say, what is AOP? Member and members of the AOP and association are one and the same. These disputes will come in. Maybe because of that only they have inserted any other law for the time being in force. Could be number one. Number two, they don't want to miss any transaction. Like, tomorrow subscription. Subscription is what? Is it a supply or is it only a contribution? It is only a reimbursement. So what they wanted to, bring out was that make it even more broader. Make it like an activity or transaction. Activity or transaction means everything will get covered. So monthly subscription, annual subscription, whatever you want to call it, everything else will covered that was not there, that was left out in section 718 in the 8 forms of supply also. So I feel that by inserting 71AA, as far as GST is concerned, they don't want to, lose in any case, at least till the High Court level, that yes, the law is stable. Like, the provisions are covered. The transactions are very well covered in the GST Act itself. If they want to challenge, of course, they can always challenge. That is always open. Somebody should go to Supreme Court, not at the High Court level. Because the same thing only was there. From 1950, we are having the same concept, same discussion. Ideally, they should have, when they drafted GST law in 2017 itself, they could have taken care of this, but they have missed it. In 1956 sales tax, clearly we are able to see the dealer definition, sales definition, everywhere it's the same thing.
Sujata madam, in income tax, except cooperative societies and cooperative bank, for all other associations, still the mutuality concept is still applicable. Correct?
Correct. Because there is some exemption, no, section 10 exemption is there. Whereas, in fact, I would say income tax has diluted this concept. See, day by day when we are, this is my understanding, okay, I could be wrong also. Society is also changing, laws are changing. So they also want to, revenue wants to have more tax collection. So what they have done in income tax, if you want to give exemption, you include it in the broad definition of income. If you want to give exemption, you come to section 10. Whatever you want to take, you take under section 10. That's the reason why banking, insurance, they are all subjected to tax. Whereas cooperative societies, associations, clubs, they are all falling under section 10, exemption under section 10. So there is some parity there. Here, if you look at it, in GST, we cannot play around like this. So that's the reason why they have clearly stated that it has to be nailed. Otherwise, people will again go to court. So in the new act, they wanted to fix all the loopholes that were there in the previous act, at least after 2019 and after Calcutta Club decision. Say, for example, if we have to say, I mean, it's since we all of us are friends, I'm saying the marriage, if you say marriage was sacrosanct, marriage means, 7 steps of this, you have to tie the knot. Those things were all there. But if you look at it now, over a period of years, our Hindu law is also changing. Now they are saying, okay, two different individuals stay together, live in relationship, that's also treated as a marriage. Legally, it is treated as a marriage. Legitimate child the child is treated as a legitimate child. That's also again common law, but it is evolving over a period of time because the society is changing. So 2 persons living together and a child is born, though without marriage, it is called as a legal child. So these kind of things are happening, not in India. I'm just saying, if you worldwide, if you see, soon that will come in India also. So same way, we may say, okay, concept of mutuality, not taxable, but courts want to be very, very clear. But luckily, this Calcutta Club decision came in favor of the SSC, because constitutionally, they cannot throw away the principle of equity. Judges cannot throw away. They cannot say that there's no such concept, because our constitution itself revolves around, preamble, if you say good conscience and justice, all these are all embedded. So they cannot throw away. That's the reason why the principle of equity still prevails.
Madam, in income tax, there is nothing in section 10 which talks about concept of mutuality. Nothing is there.
No,
It is the judge-evolved law. Okay.
Correct.
Now, as far as income tax is concerned, on certain transactions, like for example, insurance companies, cooperative bank, they have gotten over the concept of mutuality. That is how it is still working. Whereas for other transactions, for certain cases, we still use concept of mutuality even today, and it is very well accepted. There's no section in the Income Tax Act for the remaining projects, except for insurance and other companies.
Correct.
Now, coming to GST, the Calcutta Club, to overrule Calcutta Club, they have introduced 71AA with retrospective date. They have also inserted an explanation. But you think that will suffice? I think there has to be another round of litigation. According to me, that will not suffice. Now, if I say, because the government is hell-bent, they want money. They do not want to leave any entity, they just want to collect tax. That's the reason they're adamant. Now, let us take, now, after your session and whatever we know, now, can we say RWAs not to collect GST and pay? Because RWA is a classic example of concept of mutuality. Bangalore, we have hosted them. Now, can RWA take a stand that concept of mutuality applies? We are no two different people. This is fundamental. So I will not pay GST. Can we take that position?
Right. At Supreme Court level only it will get settled. But if you are willing to litigate, yes, definitely it will prevail.
Okay, now, why don't you look in the light of Rule 33, where we have this concept of pure agents?
Correct.
If I say, all right, I fail as far as concept of mutuality is concerned, but I will go to Rule 33. And generally what happens in RWAs, they collect to the extent of what is about to be spent every month or every period. It could be a quarter, half year, or whatever. Sometimes they collect a little extra for future contingencies. Okay. Now, to 80 to 90%, I can fit into Rule 33, pure agency. So then where is the need for RWAs to ideally collect and pay? If they fail concept of mutuality, I will get into Rule 33. Don't you think that is possible?
Sir, very much possible.
No, I don't think that is possible, sir.
Why is it
Because
not possible,
yeah.
Mylar sir? It is very much possible because BESCOM, I collect to that extent. In my books of accounts, one debit, one credit. End of the year or end of the period, it will be zero. Why can't
correct.
I do it? Water
Sir,
charges,
yes.
security charges, everything.
No, there are so many things.
Everything. I'm telling you, 90% we can fit into pure agency. We can. It's possible.
No, where the invoices are in the name of association.
No,
Where
I will ask them to bill it various,
Do it,
occupants.
sir.
I will ask him to change it. I will say to various residents of so-and-so, apartment complex. Possible, why not? I will not take any credit. I don't want.
If they don't pay, who will be responsible, sir? Like, I mean,
and again common area.
See, now the question is many, because some of the RWs, when we are handling some of the big names, the only question was today, unless you litigate, we don't know the position. Because many a times the residents leave and go, tenants leave and go, so nobody wants to build the cap. So that is the reason they are taking a safe position. They are collecting anyway, the residents are paying. But technically, either you hit into concept of mutuality or you can go under Rule 33. It's very much possible, but only thing you should have stomach for litigation. Now, madam, continuing the discussion further, I can draw parallel to Section 87 of the CGST Act, which talks about amalgamation, transfer in certain cases, how the demands, if you go to Section 87, it clearly says transferor, even after the date of amalgamation, is still liable. If any notices are there, is still liable. But technically, in an amalgamation, the transferor becomes part of the transferee. A entity getting amalgamated with B entity. So after the date of amalgamation, today under the Companies Act, it is NCLT which gives you the date and all, which gives you the permission to amalgamate. Once you amalgamate, entity A doesn't survive. It is only entity B. But Section 87 says, till if there are any orders, any notice, the old, the non-existent entity should be liable and they should pay it. There is a section. There are just 2 subsections there. You can check. Now, recently, I think yesterday I was reading a judgment. Certain high courts, they've said, look, even though it is there in Section 87, but we can't forget the fundamentals. When the entity is non-existent, how can we ask that entity to pay? If you want, you go back to the new amalgamated entity. So they have ignored 87, section 87. It is not a rule, section 87. And they have upheld the principles of amalgamation. They have clearly said once an entity is amalgamated, then the entity A does not survive. So if at all you have to give a notice, a demand or an order, it has to be on the newly formed entity. It can't be on the old entity, despite there is a provision in 87. You can check 87. Now, if I draw parallels, no, in spite of section 7 on AA and the insertion explanation, not only me, certain legal experts, they are of the opinion that Calcutta judgment still holds good. In GST, they have not gotten over the concept of mutuality, is what they are believing. But of course, somebody should have stomach for litigation. Only then things will survive. I mean,
Sir,
I thought I'll
Vijay
just
sir, can they bring out something saying that notwithstanding contained in any other law for that? So can they bring out such kind of explanation, sir? Because I have never seen any such explanation in any of the laws whichever we are going through, where they can overcome saying that the judgment of court or any tribunal or any authority. Can such be explanation be inserted, sir, in the law actually? Because to
Madam,
overcome
they
Calcutta law,
cannot, because see, one is the transaction. Certain transactions are, there are allied laws also. We can't just say GST. GST is not the law that
yeah.
it only gives you the mapping of the taxes. Only
Correct.
once there is a transaction, then the taxes will kick in. But the
Yes.
fundamentals, whatever it is there, if I'm a company, I have to first follow the Companies Act norms. If I'm a
Yes.
partnership, if I'm a society, if I'm a
Yes.
club, so according to me, concept of mutuality should apply. I don't think this notwithstanding retrospective will apply, but somebody has to take it up. Somebody, in fact, one very big RWS in Bangalore, we tried convincing, but they said, no, sorry, we cannot, because we have this practical difficulty. I told, if not concept of mutuality, at least Rule 33 will come to your aid. But somehow things didn't work out. But they are all scared.
This Rule 33 will come into picture only if there is a supply in the first instance and there is a recovery or reimbursement. But here in your example, entire reimbursement, I mean, whatever the money is collected from the members is, you cannot consider it as a pure agent, no?
No, we can.
Should
Kuber
be
sir,
a
what will
supply.
happen? Let us take security services. We should ask him, don't bill in the name of RWA. We should say you bill various residents of so-and-so apartment complex. Now, money will be transacted through RWA only. RWA will be only a via media. So now in this situation, now who is the service provider? Who is the service recipient?
Sir, you think it is practically possible for the
Very much, madam. In service tax,
1,000
people have done it.
apartments, 1,000, the security agency will be able to map 1,000 residents.
Yeah, he'll just raise one bill, madam. He'll say various residents.
Security services in the front gate for your apartment.
Madam, what happened? The transaction, see, why I'm telling you is this all was happening in service tax era. People have done it.
So people might do it, but when in the first level, when they see the contract, okay, when somebody is facilitating.
One second. Vijay sir, if that was the case, then what is the requirement of RWA? Why they want an association? They can directly.
RWA is only a via media because what happens? Now let us take our own Bangalore GST study circle. We are about 15 people. Now what happens when it grows? You can't be running like this. One, Venu sir cannot be handling everything. So that is how maybe you become 100 or 200. Essentially, we give a form of identity. It's only a question of identity. Then we say, okay, we will have an identity, whether it is a society or an association or a trust or whatever you want, a club, whatever you want to call. It's only an identity. And then we will nominate some executive committee members, maybe office bearers or whatever, to look after the affairs. So it is only a mechanism, as a convenient mechanism, but still, what is an association? It is an agent of all of us. Now, tomorrow, when the numbers grow to 100 or 1,000, it's difficult. One person cannot manage. So that's the reason we have this form of association register. We have the bylaws so that everybody follows. But this does not defeat the concept of agency in principle. The association or the society or the club, you take the respective laws, they are like an agent of the members only. So, I mean, in my personal opinion, this 7 on AA will not help. According to me, concept of mutuality has not been gotten over in GST laws.
Sir, I disagree to your points on pure agency possible, sir. So imagine the privity of contract between the security agency and 1,000 apartment owners. Apart from being impractical, they wouldn't be willing to take that risk of, having the responsibility of collecting all that and ensuring the enforcement of the contract with 1,000 odd people. And again, the question comes, what happens to the common areas? So the principle or the rule 33 is multiple conditions to be fulfilled with a strict implementation of all of that. Otherwise, it will definitely fail. I am of the view that definitely pure agent cannot be used as a tool for doing away the mutuality principle here.
I agree with Annapurna Srikanth.
Madam,
Even
now
I
you are directly jumping to GST. Let us not come to GST. First of all, what is RWA? You are registered as what? You are registered as a society. What are you? In a society, it is basically you are representing the members. You are no different. It's not a company wherein we can say that this is a different entity. No. You have to go to the fundamentals. What is RWA? RWA is a society. Sometimes RWAs can be a trust. In Bangalore, there's a controversy going on whether it can be a cooperative society or not, or it can be under Karnataka Societies Registration Act 1960. That issue is still going on. But anyway, what is RWA? RWA is a society. And what is society? It comprises members. So according to me, RWA is only a phase of the members. It's only it's like a via media, because 1,000 people cannot handle with the security service. 1,000 people cannot pay the BESCOM bill independently. That's the reason we bring in the RWA. Even common area maintenance. So we form, it's again our own. RWA is nothing but of the members, for the members and by the members. So if you really go into the laws, then yes, you will understand it is nothing but an agent of the members. Now next you come to GST law. Madam, we have done it in service tax era. Now in GST, people are scared. Like I'm telling you, certain big societies in Bangalore, they're scared. Because tomorrow we don't collect. And we don't know 10 years down the line how the judgments will come. We don't have stomach for litigation. That is how things are just moving. I mean, this is another facet of it. So you can think about it, madam. No problems.
Vijay sir, I think recently that High Court judgment was pronounced that it is covered under Karnataka Apartment Owner Association and not that cooperative society. So will it has its impact for us on this doctrine of mutuality, sir, like what we are discussing now?
Madam,
Because-
now they are saying, yes, you form under the Karnataka Apartment Owners Association.
Yeah.
That is only the instrument. But
Yeah.
then you think, again, it is for what? I need to examine. I think maybe Sujata madam can throw light, because she must have done some work on the
But
apartments,
those are all
that act,
completely
whatever
different
Karnataka
issues.
Owners Apartment Act.
Those are all completely different issues. I don't think that is not anything to
No,
do.
that is only, madam,
no.
according to me, that
One
is only
thing,
for the purpose of drawing up an
mutuality.
instrument.
Yeah. See, Sujata, what happens if it is covered under Cooperative Society Act? We are trying to prove that yes, it is forming a association of person, and accordingly, we are trying to test the doctrine of mutuality. Now, because of recent judgment, it is covered under Karnataka Apartment Owner Association Act and not under Cooperative Society Act. So the question here is whether still that doctrine of mutuality, what we are looking, whether still it applies to residential welfare associations.
Yes, ma'am, it should apply.
Very much.
It
See,
should
that-
apply.
That
Yeah,
principle
that is
will
what, yes.
prevail under whichever
Yeah.
act you register under. Whether you register under Companies Act or KOA Act or wherever you register, the principle will remain the same.
Madam, there is a difference. If RWA registered as a company, then it's a different
Yeah.
ballgame altogether.
Correct.
So that's what. So if you register as a Section 8 company, what happens in that case? Where will it get covered? If it is unincorporated, incorporated, because if you see a person, it says only, if you look at Section 284, it says only the club association. It does not say whether incorporated or unincorporated. So it can be registered under KOA or say any other act societies. And company is covered under the definition of Section 284.
Madam, Section 8
person.
company also is a company. So you are definitely out of the scope. You can't say I am a company and I still, enjoy the mutuality concept. I don't think that will work out. Whether it is Section 8 company or a regular company with liability, without liability. Once you are a company, you are separate. You are a distinct person. That's fundamental. I don't think we should draw in companies here. Other than companies, yes, there is a possibility, is what I was trying to explain.
So whether you register under KOA or trust or society, the concept of mutuality will always be the same, will prevail.
Yes, it should.
So coming back to this, a conclusion. So can I request our group leader, Venuji, can I request our group leader, to confirm my conclusion?
Madam, I have a question.
Ah.
Okay, Vijay sir, this 7,500 for RWA we have limit.
Yes.
Vijay sir.
Yes, sir. Yes, sir. Please, sir. Venu, sir.
So do you think that that provision itself is invalid in the law?
Actually, it is not required. But again, as you know, even there's a litigation going on up to that is again,
Okay, up to,
litigation.
I understand that's a different tangent. My question is, let's say someone is collecting 10,000 rupees.
Correct.
Monthly maintenance.
According to
GST
me,
would be leviable?
According to me, that entry is not relevant at all. If you really follow the concept of mutuality, let it be 10,000, let it be 15,000. According to me, that entry itself becomes irrelevant.
Okay, so that is where like now we are fundamentally asking, we are challenging that entry.
100%. 100%.
Yeah. So for a moment, I would consider that entry is valid and it exists. Okay. I don't want to get into that aspect of the debate. But yes, now the question that needs to be challenged is the mutuality when we are looking at. Which Kuber also asked is like, okay, that entry was there even before 71AA came in. Now, bringing 71AA, what aspect of that entry, considering for a moment that entry is valid, after having that entry being valid, 71AA has come in, what else it has done to that entry? Where did it expand the scope of that entry? Like, I'm not challenging that it doesn't fit in. Now, having fit in, what did it do?
Venu, sir, it's a pure economic, or I would say it's a policy decision of the government. The government is very, very clear. Look, if everybody starts litigating, let us say they don't have this entry at all, then every rupee will become taxable, the way things are happening today. So that's why initially up to 5,000, now it is up to 7,500, so that at least 50-60% of this apartments or cooperative societies in Mumbai, Maharashtra and all, most of them will be out of the net. So that they are trying to reduce litigation. It's a pure economic decision, but somehow the government, by hook or crook, they are not ready to let go of this. They still want to deem RWA different from the members and they want to tax it. It could be 7,500 today, tomorrow they may increase or they may decrease. We don't know. But yes, it's a pure economic decision. Nobody can question why it is only up to 7,500, why not more, why not less. So that is an economic decision.
Kabra madam, you were saying something.
Yeah, that is one point. Just trying to argue on that. And the second point is 71AA. I think it took more importance because the definition of service, if you have seen, supply of service, specifically they excluded that mutuality concept, though it may not be required. But in 7, we are trying to say that something specific entry was required because it is a transaction between a person to its members or the transaction between members to its person. So they are trying to bring out the transaction between the association as well as members and members to association, which they brought out by a carving out from 7A and bringing out a separate entry for 7AA. That's why I think if you read that, they have also used the word as vice versa, which is not there in 7A. So that is one more distinction which we can read for 7A and 7AA actually. So what I understand is only to bring out this, overcome the principle of mutuality, concept of mutuality, they have brought out 7AA. And though it is we are applying that Calcutta Club is not applicable, but still I still believe that the doctrine of mutuality will override this section 7AA. Though most of us club are paying GST today on this, whatever the charges they are collecting from the members, but still the doctrine of mutuality is not specifically stated here that it doesn't hold any good as such. Though they have brought out that judgment will not hold, but they have not brought out something saying that the principle of mutuality will not hold good. That is what I'm just trying to bring out this.
Annapurna, see, in statute, they cannot explicitly say that doctrine of mutuality is overruled or anything, right? So because they cannot say that. Ultimately, it's a fundamental principle, it's a fundamental right, right? It comes under the common law, so it cannot be touched. Nobody can touch. But the statute has got its own powers to, fix any deeming fiction, any deeming provision. Say from one branch to the other. If you look at GST, there are two distinct persons, and blindly they can say that this transaction is taxable. That power statute has, provided it does not violate the constitutional provisions. That nothing wrong in having this provision is that what I'm trying to say. Section 7(1)(a), if you independently look at it, there is absolutely nothing wrong in covering member, explicitly covering.
That is a specific section over general section. I agree with that. 7AA is specific over section 7, and that's why they brought it retrospective. All that is it. My only issue was they have brought out saying that not withstanding content, that's what. So the doctrine of mutuality was appreciated in Calcutta Club. It was identified in Engman Club case also, and now they cannot bring out saying that that is not applicable. That is what I'm just trying to bring out. See, that principle still remains the same. Whether you are applying here or not applying in GST doesn't. I'm not looking that way. They have brought out deeming fiction saying that yes, it is liable. That also I agree. But what I'm saying that they cannot override the doctrine of mutuality by bringing out this kind of explanation is what I try to bring out with this. This is what I'm just trying to highlight on this. Because that is a universal concept. That is a general, that is a doctrine which cannot say that it is not applicable. You cannot bring out that kind of exclusion from this entry. That's what I'm just trying to say. And if you read that Engman and Calcutta Club also, the major difference was nothing like, only it was a difference of unincorporated association and incorporated association. That is what the major principles, if you see in Engman case also, and if you see in Calcutta Club case, that is a distinguished features with they have brought out, because Calcutta Club was an incorporated association, whereas Engman was discussing on unincorporated association. So that's why I think if in the definition itself, they have brought out saying that whether it is incorporated or not, it is still called as it is still deemed as a association of person. So I think to overcome all that, they have already made a changes in that person. But this is a specific entry over the general entry. Only to the extent of this, I'm not accepting, to the extent which is the principles which are contained in other law. To that extent, I'm not very in consent with the principles of the law, what I'm trying to bring out here. They cannot bring out such things in the law. That is specific point I would like to add here.
So you mean to say that they can't have overriding provisions for the other laws, is it?
No, what I'm trying to say is they can bring out a deeming fiction that, but they cannot say that it notwithstanding anything contained in any other law for the timing in force or any judgment, decree, order, or any court, tribunal, they cannot bring out something which has already been tested in the courts of the law. You cannot say that it cannot happen. They have to bring out a specific deeming fiction entry, but they cannot bring out this kind of entries, what my reading of that section actually. See, because the
non-obstant clause shouldn't have been there is your point.
Non-obstant clause should not be there, but they would have brought this specific deeming fiction entry. That is what I am trying to say. They can say, yes, the transaction between the association to its members is deemed. See, we have a concept of deemed pure agent in a circular 206. If you see, for that electricity, whatever this residential welfare association or real estate agent, which they are collecting from their members for electricity by placing a separate meter and paying the tax by getting an exemption, they brought a specific circular by bringing a concept of deemed pure agent. So something they brought it a concept of deemed supply by inserting 711A, but they cannot override the principles of law, what I'm trying to highlight here actually. They cannot say that, no, it cannot notwithstanding anything contained in any other law. So that is somewhere I'm not able to go in concerns with the section supply actually. Yeah.
Annapurna,
Madam?
I have two questions. So what even if the explanation is challenged? Because of 71AA, so nothing changes, right? Explanation has been inserted by way of very abundant caution to prevent any disputes. That's my first question. Even if the explanation is held to be not,
Bhunesh, yeah,
does
just
it
to you see, without this explanation also, the deeming fiction entry will prevail and the principles will remain the same. But by bringing this entry, somewhere it is bringing a conflict with the principles of law, what we are reading, and whatever the principles which are stated in the judgment or law, whatever it is, that will contradict it to each other. So this is not at all required according to me, because this is not something abundant caution. It is something which is creating a conflict among itself. When they have specifically brought a deeming fiction entry, then where is the requirement of bringing out this explanation? And it is also saying that it has been clarified. So it is not something a clarificatory. It is something which is not required in the GST law itself. And you cannot bring out a deeming fiction by way of clarification. It is by way of entry you have brought out. You cannot bring out by way of explanation the deeming fiction. You cannot bring out by way of clarification. That is what I just want to bring out here.
Madam?
but this
Yeah,
explanation in
Bhuneshwari,
no
yeah.
way dilutes 71AA, right?
See, 71AA, it's remained the same. I'm just talking on this
It can't
explanation because,
expand.
yeah, it cannot expand beyond this.
And the second thing is, why are you saying they cannot have notwithstanding anything contained in any other law? I agree, you can't say notwithstanding anything contained in any judgment, decree, or order of any court. Notwithstanding anything contained in any other law is only to the extent there are contrary provisions in any other law. When there is a conflict between GST law and other law, then this provision prevails, right?
Yes, I see here they have used the word contained. They have not used the word contrary. That is the one thing we have to understand. And the second thing is they are not only restricting, they have given or. It's not that something they're reading these principles with their judgment. They're also saying that notwithstanding anything containing any other law for the time being in force. So there are multiple laws which are there. It cannot be. And then they have used the word or any judgment, decree or order or any court or tribunal or authority. I don't know which authority also they are talking. So what I'm trying to say that this is a very contradicting with the principles of the law, with the jurisprudence. So I feel that according to my view, they wouldn't have brought out this explanation. That is what I say. This is not going in accordance with the 71AA. Without that also the 71AA is operative. Calcutta Club was under service tax decision. It is nowhere as a GST decision. So you cannot say that you can bring out this explanation and say that you are overriding Calcutta Club. Though it is pronounced in the GST regime in 2019, but still it was argued based on the definition of service. It was not argued on the definition of supply, which is there in the GST law. That is the thought process I'm just adding.
Can I add something?
Yeah, group leader, please add.
Oh, thank you, Annapurna madam. See, we are discussing about this. This is a concept. This is a concept. This is not a law. So, concept of mutuality, all these things. This is not a part of law. Now, when we come back to the law and look at the provisions, we go to the main basic provision yet again. I also heard Mailar about distinct person and related person comment on that, and I also heard Vijay sir. When we go back to the law and see the person, an individual is an individual will qualify as a person. An association is also a person. So when we go back to the definition of supply under section 7(1), by a person in the course or furtherance of business for consideration. So when we can distinctly consider these two as existing two different persons, then there was no requirement for, according to me, to have this amendment 71AA. This is again a concept, and they cannot try to overcome the concept. So there was a law existing then also, and therefore I am looking at it that there was no need to bring in this amendment. Now, what has happened when they have brought this amendment? They are admitting that, okay, this was missing. So this was missing. This was not a part of statute, and this was not the supplies between the association and the members was not taxable, and they are bringing in this amendment. So when they are doing this, so all these compliances and registration requirements and taxability with effect from 1st July 2017 will come into place. Now, who was paying tax then on these supplies between the association and members? He would have claimed input tax rate and all that, but association which were taking this applying this concept of mutuality, they will now come into the net of the GST, and they have to comply with the law. Now they will pay the taxes in 2021 for the supplies effected for July, starting from July 2017. Now, according to me, concept of mutuality is only a concept. It's only a principles of mutuality is only a concept, and that is not a law. And law was very clear then also. And there was no requirement for Mylar made a comment that, okay, distinct person and related person. So there was no requirement for the lawmaker to bring an amendment to consider association and the members as distinct persons or related persons. They were two different persons then also prior to amendment, and after that amendment also it is only bringing in the clarity. So these were my few of the comments. I thought, okay, if anything else is there, if anybody else who wants to add anything on these things, can add their inputs. And Sujata madam.
I have a question.
Kuber, one more point I just would like to add here. See, 71AA is not including an individual, right? So specifically, they have excluded the definition of the individual from the person definition. That is the one thing I think they have made it. And second thing is there is also a concept of vice versa, which is not there in 7A. So I think to specifically to bring out the activity between an association to its members or from members to association. I think this is one more difference we can bring out here. Yeah.
I think Venu sir wants to ask something.
Okay, you have already put up the questions, so yeah, we'll look at.
So this is my conclusion.
Can you go to the previous
So these are the questions given by my team. So I'm just placing it before all of you.
The third question was now the 71A and 71AA. I am again going by RWA 7,500 limit. Will still cover under 71A the transactions of the association with its members. Even before 71AA came in, that existed, the 5,000 limit and the service tax also existed, and the levy was there. With 71AA coming in, what is it covering the activities or transaction vis-a-vis the sale of goods or service is something not explored.
See, what I understand from your question is that actually it's a very good question. If you look at only 71A, right, and the notification, which says that up to 5,000, 7,500, whatever, there are two sets of services. One, fixed fee. If you go to clubs, per month there is some fixed fee. Whether you use it or don't use it, there is some fixed fee, right? Whereas if you go to associations, there is common area maintenance, which is like projected, budgeted, and divided by number of apartments, which is collected over a period of 1 year. So it's more like reimbursement. When you look at 7.1 independently, when I say subscription, there is no supply involved. To become a member, you are paying something every month. What is the supply the club is rendering? Nothing. So why do they collect? Is it called as a consideration or is it called as a reimbursement? You cannot fit in. So people taxpayer might dispute. Whereas if you bring in 71A, 71AA, activity, the minute they include activities or transaction, it covers the subscription also. It is a very broad, activities or transaction is a very broad. And 7.1 is a subset of 71AA. So I feel that that is the reason why the association will fit under when they collect some subscription is a right giving, including the entity. Is it a clear supply? What is it service they are rendering? Subscription? When they collect
So if you
subscription?
giving the subscription, you are giving an access. Like Taxman subscription I have. So they are giving me the entry to the website. They are giving me entry to the club.
No, even for
That
any,
itself is a
assuming it
service.
is- it's a fixed fee. See, you have to pay whether once you become a member, whether you use it or not, you have to pay for over and above that for every
Having,
usage.
having
It is an
paid,
entitlement, no. So
Entitlement,
by
okay.
subscribing, I get that entitlement. I use it, not use it is secondary.
but
Correct.
that right to use is there with me.
So does it fit under any form of supply? 7.1?
Yeah,
There
it
is-
clearly fits in 7.1 supply is my view. Earlier, I was not entitled. Now I am entitled to do something. Whether I'm using or not, but I have been given the right.
Under which form of supply?
It's a sale of right.
So
A right has been sold to me.
No, it's
It is
like
like
maybe
movie
we
ticket. I
can
went
take
or
it
not
like
is
a
a different. So subscription gives me an access.
okay. So subscription gives you an access. So you mean to say it is already covered under 7.1A?
Yes, yes,
7.1A itself is not required, you are saying.
yes. And that is where I want to again bring this third question, the distinction between the sale versus the activity. And I strongly feel 7.1AA is not subset of 7.1A. In terms of the positioning of the act, it is in line with A. So AA is not, is like, it is not, though it is between A and B, AA is not subset of A. AA is an independent limb.
See, where do you classify reimbursement then? If you want to tax some reimbursement under 7.1A, will it fit in?
See, as far as the
Ganesha Puja.
subscription is concerned, it is more like a licensing.
Okay,
Yeah,
subscription.
permissive rights. I mean to say
I-
permissive rights.
Correct. I
So
stand.
it will,
corrected. Subscription will not cover under 7.1AA. 7.1A it fits in. So where
Correct.
do you fit in reimbursement? Ganesha Puja.
no, what exactly, what is the reimbursement? What do you mean by
For
reimbursement?
some event they collect. Okay, some group of members, they want to celebrate Ganesha Puja. So they pool money from others and spend it. There is no profit element, nothing. It is only a reimbursement. They collect a
see,
bit and spend it.
correct, I understand. See, but there is no one-to-one excess. Who is contributing for which expense? No,
And it is not even reimbursement.
it is not even
Just a
reimbursement.
donation without any quid
Yeah.
pro.
Donation. You will call it as a donation. Donation for what? Some 10 people are donating for conduct of puja, Ganesha Puja, and spend
Yes.
it.
More in nature of donation, madam.
So I was thinking that it will covered under activity or transaction.
But Mylar, again, it is for a specific purpose donation only, no?
Correct,
Because
correct.
it is for the Ganesha Puja, they can't
Yeah.
use it for
See,
anything else.
Correct. Any donation, we have that specific donation and general donation.
General donation, yeah.
Whenever is a general donation, I am not specifying the end usage. Whenever there is a specific end usage, then it will go only for that usage. That is how we trust we have two categories of donation.
I think there should be some common parlance for that. If there is a common commercial purpose in that donation, then we are taking the color of consideration. If it is not having any
correct, as per the circular, if they put the big banner and also indirectly
some
they're
commercial
promoting, then
reasons,
there
then
is
it is
a
good.
different.
Yeah.
Where there is nothing is there, I want the simply Ganesha Puja where I
Yes.
contribute. without any display or promotional activity.
Yeah, then I think we can take that, yes.
So now I definitely want a view from the members for the question number 3. And I strongly believe 71AA is not subset of 71A. It is an independent limb. Do you believe that, like Sujata Madam said, that it is a subset of 71A? Now, I want the members of the views of the members that it is a subset, or is it a separate levy under Section 7?
Sorry,
It is a scope of
I,
subset.
I stand
No, it is-
corrected. It's not a subset, it's a broad, like, when you say activities or transaction, it covers everything. Sale, this, that, everything, all forms of supply are covered. It's a very
Activity
broad
or trans, yeah,
Are you
activity
saying
or
that
transaction.
71AA is sufficient, we can remove 71A?
You
No,
can't
no.
remove. You can't remove because it has got other furtherance of business, other things are there. I am saying the word activity or transaction is broader as compared to sale, lease, transfer.
71AA is targeting by a person to its members. It is not targeting regular transactions. So now I strongly believe these activities and transactions listed here is also to be looked into for the purpose.
When sir, we lost you.
No, I'm saying the activities or transactions listed here is not examined in this discussion is my point. And something which doesn't fit under 71A. I'm not looking at the transactions that fit under 71A. What is that is not fitting under 71A and covered here?
See, when you raised this question, subscription came to my mind. Now reimbursement also, something else other than the date, whatever is missed out also will get covered under this activity or transaction list. It's a very broad one. If you are not able,
Now, what is that is something missing?
what is that? I am not able to think of an example. I don't know what is that. See that Ganesha Puja when you gave, I could think of that. Some reimbursement or some
Yeah, but
kind
now
of.
Ganesha Puja, Mylar is saying that it is a donation without quid pro quo. So hence it's outside the scope of levy. But Annapurna Srikan brought a point saying that this is a specific purpose donation. You wouldn't give this for Ramzan celebration. You are saying that, okay, you will bring Ganesha, you will do this. Hence, I am giving it to you. Like I'm giving it to you because you are doing this here in my apartment. You are doing this. It's like you are inside of you doing all this. I still feel it is a consideration, and I will say that it is not quid pro quo. And the taxes can be levied. What is that I am getting is like you are bringing the god to the premises here, and it gives a good aura, everything.
Sir, then there'll be all donations in the trust. Everything will get taxed. Sir.
Agreed, my lord. So that
Yeah,
is
you
the point
see,
I'm bringing.
yeah, because see, any trust have a specific funds will get created for a specific purpose, and all the donor will have a background that it should be used for some specific social cause. It cannot be that see, quid pro quo and specific social cause are different. See, for a general well-being is different, and directly I am getting benefited is both are different.
Exactly. So, my lord, so what I am trying to bring here is the wording in 7AA is different from 71A. I am talking quid pro quo only when an activity done by a person to its members. I will not apply the principle of quid pro quo. While in 7.1, there should be a supply of goods or service. So that is missing in 7.1. So the donation would be outside the levy when it comes to 7.1A. Malar, you are getting the distinction
Yeah,
which
yeah.
I'm trying to bring.
Got it. Got it. You're saying 7(1)(a) because there is a consideration quid pro quo.
Yeah.
Donation is outside. If anything, it is there in 7(1)(a), then I
Yes.
should not apply all these things. Any activity transaction, whether there is a quid pro quo or not, it should be covered. That's what
Should
you're
be
saying.
covered. Exactly.
Got it. Got it.
Sujata madam. Case is rested.
Yeah, yeah.
Sir, again,
So the element of quid pro quo or consideration need not be examined when you come to 7(1)(a).
I'll just differ.
I am
Venu
not
sir.
concluding. I am giving my
Venu sir.
argument.
Again, you consider this 7(1)(a). Okay, you're saying, but to become a levy, the 9 is also applicable. Any transaction or activity that becomes a supply of goods and services.
9 is a byproduct, no, Malar. So if 7 is fulfilled, 9 is trying to fit that. So the moment
service it is getting added, no, sir.
It's a service. The moment it is not a goods, it's a service, and 9 is only to place the right HSN, right, all the elements. That's all, value and everything. If 7 is passed, 9 has very few scope for escaping. Kuber and Annapurna Kabra madam, your views also.
I'm just trying to, one more point is I'm just trying to read this constitutional amendment also on the definition of this, where they have not discussed on anything as such person or something. They're just trying to say it's GST is nothing but a tax on supply of goods and service. So somewhere they are not very specifically used at by percent, 2%. So with that amendment in that definition of GST, if we see, they're just restricted to only supply of goods or services. So with that, only I think what I'm just trying to say that even though this Calcutta Club has come and the principle of mutuality has come, but that they have not amended the definition of person or business with the 7(1)(a). That is the thing I'm just trying to test with that, with your example. See, if they wanted to bring out 7(1)(a) specifically and not a subset of 7(1)(a), they would have also simultaneously amended the definition of person also as such, or the definition of business, but as such they have not done anything. So can't we say that it is a subset of 7(1)(a) only? Is one more thought I'm just trying to read that actually. And the second is they brought it retrospectively. So it's nothing but just an addition to 7(1)(a). Hello. Am I audible?
Yeah.
Yes.
Yeah.
So anybody has any other views?
Venu sir, again you consider, see it starts with to its member or constituents vice versa. So indirectly there is a quid pro quo because one person to another.
Correct.
That is required. So still I feel quid pro quo is required.
Okay, I will re-examine.
Sujata, why did you say that it is retroactive and not retrospective?
Because it goes back in time and then redefines the class of persons. The deeming fiction, whenever there is a deeming fiction, it goes to the past period and makes it prospective. So that's why it's called retroactive.
See, I remember Raghuraman sir's one example for this retroactive thing. That refund related rule modification came.
Correct.
So what has already happened before amendment, let's say, I mean, within the 2 year span of time, I'm eligible for refund filing. If I already filed it, then it is not applicable. But it still gets covered under within 2 years, and I file now after amendment, then it gets covered. So that is what he says as the distinction between retroactive.
Correct.
So how do you say this is retroactive? I think this is retrospective.
No, it is retroactive only because the class of persons, like earlier, if you look at it in 7.1a, members and the association, there was no two different distinct person was not explicitly stated. Now it is explicitly stated. That's what I understood from his, discussion which we had in some CGPI. He took the session, right?
Correct.
I wrote one article just after his session. Okay.
Correct.
So in that, that's what I understood, because say from so-and-so date, I am apple, you're orange. Annapurna is equal to Sujata from so-and-so date. That means the new classification is created from the backdated, it becomes prospective from the backdate.
So what is the effect in effect of this?
In this case, the effect is that this section 7.1a, that is member and association, are two distinct persons were established from the day of 1/7/2017, which came as a retrospective amendment. So it is a retroactive.
No, ma,
Earlier
see,
it was
like,
not.
in effect, let's assume two things. Let's assume this is retrospective amendment.
Correct.
Let's assume this is retrospective amendment, retroactive amendment. So if it is a retrospective amendment, it means that even past periods, all the associations and clubs are liable to pay GST irrespective of they collected and all that.
Correct.
So because you're calling it as a retroactive amendment, what is the impact and effect?
The impact, what I feel is that you cannot go back in time and collect tax. You can always challenge it, saying that it is a retroactive. Whereas if it is a retrospective, you do not have a choice. It could be some error in the law, or it could be some wrong interpretation. If they make it retrospective, then you are liable to make the, pay the taxes or whatever. But
what makes you think that it is retrospective, retroactive, like any specific drafting style, or I mean, I didn't get that point.
So there is a word called deemed. If you look at 7.1a, deemed to be, that word is added. That is what makes it retroactive. If you look at 7.1a, no, in that
Explanation.
Explanation.
What is the view of others? Is this retrospective or retroactive?
I feel retrospective only. I don't.
Yeah, retrospective only.
I
feel
also
it.
feel it is retrospective and not retroactive.
Retroactive where transaction already commenced in the past, which is
Correct.
ongoing, and we will make it applicable even for an ongoing project.
Yes.
It's something like that.
So you mean to say this is not retroactive? It's only retrospective?
I am of that view.
Yes.
Others?
Yeah, even I concur with Annapurna.
And even the language of that explanation is also giving the implication that it is for a retrospective impact actually. And and one more thing is whether it is a statutory amendment or legislative amendment or clarificatory amendment, that is also one of the challenge in this explanation actually. Because in the explanation they have used clarified, and somewhere they brought it out the activities or transaction by a person. So that is also one more entry they have added, and again they have clarified also. So I think it is a retrospective.
I felt it is retroactive because it uses the word deemed. Okay. Second, the class of persons are also reintroduced. in one video of Arvind Datar, no, he clearly explains about what is retroactive and retrospective. There also he says, he gives the example, a chartered accountant will be deemed as a lawyer from so and so date.
No, but the word usage of that deeming fiction, it is to create a deeming fiction, right? So factually it might be different, but for the law purposes, it is deemed so. So that fiction is created for the purpose of law.
Jyotamino, if you can share that video link, we can stand corrected also.
I will check it.
Madam,
Huh.
see, my view, 71AA is definitely retrospective, but the explanation which has been added and the impact, any impact arising out of the explanation is retroactive. The explanation cannot be retrospective. It is retroactive because it is now a deeming fiction, like that example of chartered accountants becoming lawyer. Now that has come to a conclusion now. So hereinafter, it would be taken it in that view. So it would be a retroactive.
Should we read or 71AA as retrospective and explanation and retroactive? I don't, because explanation is only for the purpose of this clause. It is not a
Exactly,
general
madam. So for
explanation.
the
So
purpose of this clause, no, that's what. So for the purpose of this clause, if something new is arising by reading the explanation, only to that extent it would be a retroactive, but the clause is a retrospective clause.
explanation cannot bring out anything new now, it can only explain what is there in that
No, but
section.
exactly.
So you
So this
cannot
this was
overread
not,
section, no?
no, this was not there beginning, no, madam. It is not an explanation to 71A. It is an explanation to 71AA.
So to conclude that, we have to first understand whether this amendment, whatever they have made it, is it a legislative amendment or is it a clarificatory amendment? If it is a clarificatory
legislative.
The legislative amendment only, it is the 7188.
But the explanation is a clarificatory amendment, madam. It's
71.
okay. It's a both have
can
come
we read both
simultaneously. No?
in different? Yeah, can we read both in different? That is what I'm saying.
So
Because
Venu
when
sir,
specifically,
sorry.
Continue.
Venu sir, now you are saying that clause is retrospective, explanation is retroactive. So
Because,
no. Okay. Agreed for a moment that you're saying that explanation is retroactive. So what is the in effect impact on GST per se because of this?
no. Firstly, I am still struggling in the clause, so I'm not going to the explanation. So I am looking at where does this clause overfit 71A? So
See, park that question aside. Now
but
you've agreed
this
that
answer. Okay, if we let's take Ganesha Puja. Okay, the funds collected for Ganesha Puja will now become taxable. Now, now the explanation
old collections,
is now.
what happened? Old collections, what happened? That's the question, no?
I would say the old collections will not be subjected to levy.
Why?
Because I believe these are part of the mutuality. I believe that okay, it doesn't come inside the levy.
Then why what do you think? Because it says enforced with effect from 1st July 2017. That entry
Correct.
Inserted later, but enforcement of that entry is with effect from 1st July 2017.
Right.
So the footnotes, it says inserted with effect from 1st July 2017 by section 108 of Finance Act 2021, brought into force on 1st January 22, wide notification so and so dated. So
no, all that I am saying, madam, is in the explanation. No, in the explanation, it said the person and its members shall be deemed to be two separate persons. Okay, I will deem that as a two separate persons. I will not deem that as retrospective because if that was not there in the explanation, then I would only go to 7-1A. But now this has come. This deeming function is made aware to me now.
Venu, this
This
liability
section,
was already, Venu, one more thing. Liability was already there in 7-1A. There was from 1/7/2017, the liability was covered in 7-1A. By bringing that amendment, they are adding it is a clarificatory amendment. So once it is a clarificatory amendment, it will be retrospective. Na? So
Correct.
how can
no,
you read the
madam.
explanation?
Madam, we are talking about a liability of gun. I am not talking about the security charges and the water
No
charges
security, no
collected.
Ganesha. I'm just trying to read 7-1 and 7-1A for your example. I am saying the liability to pay GST was already there from 1/7/2017.
It is
By
not there. Even
inserting,
today itself, we are debating. No, like if I
no,
do funds raising for Ganesha Puja, will it be liable to GST?
Venu
no,
sir, they're confusing the discussion.
no, we are
Let's
discussing on
address one by
retrospective
one.
and prospective.
No,
We
no,
are
no,
discussing
no. I
on
agreed. No, no. I get the
when
point. I am saying that if something is liable to tax now, will it be liable to be taxed on that date? Also, is my question.
wait no 1 second. See, we are discussing on the issue of retrospective or prospective, whatever it is. My question here is 7-1A had already the liability to pay the tax on this transaction. By inserting 7-1AA by overriding Calcutta Club case, they are bringing out an explanation by saying that it is clarified. It means this, and they have specifically stated it is from 1/7/2017. So it will take the color of retrospective. That is what we are trying to stress here.
No,
Why it is retrospective? We are just trying to stress here that because liability was already there in 7-1A, only by AA they have brought out as a clarification, and based on that it is liable. So it
if
is a
that being the
retrospective.
case, no, if that being
So
the case, the
huh,
1AA could have itself had been come as explanation, no, madam.
that's what I'm saying. This explanation is not required only. That's what I was also trying to stress upon. This explanation is
No,
nowhere
no. I
having any
think
relevance.
having come into
Venu
that,
sir,
we can.
Venu sir, again, when the clause is comparatively more powerful than explanation. I mean, it has more
Correct.
sanctity. So again,
Absolutely.
there should not be litigation per se. If your point is that after 7-1, it should have been 7-1A, it should have been directly an explanation to 7-1A, not bring in 7-1AA and then explanation. That is your point, no?
No. I am only saying if what Annapurna Kabra madam said was true, then it should have been that way. I am saying that that is not true. Since that is why they brought this as a separate section.
I think
Bring
Annapurna Kabra will definitely, bring these aspects. I think there are many judicial precedents which say that whenever it is an explanation or clarificatory in nature, it is retrospective.
it
Correct,
as
no?
retrospective. That is
Yeah.
there is no doubt in it. I don't
Then
is
when
like
you say
even
that
16 and
explanation is
17 we had an explanation coming in that is retrospective because the section was existing from the day one. Anything explanation which has been brought to an existing section is operating from the day that section is there. This explanation has come in to a section which has come in new.
clause which has come in.
Yeah. So the explanation dates to the date of which the section is in operation.
So since the clause itself is a retrospectively enforced clause, so like in your own words, even that explanation goes by the clause itself.
No.
So both are
Clause,
retrospective.
clause brought in today with a retrospective effect. So the clause has a retrospective effect. I don't deny that. But the clause has been brought in today. The explanation validity will be from today.
Okay. What is the practical implication of the stance you are taking?
I have no answer to that. Firstly, this entry itself, I'm still struggling. So
what
No,
will
if
be
we
the
can
taxation?
understand with two examples to distinguish if both clause and explanation are considered to be retrospective, what is the implication? If
madam,
only
the
clause is
entries in the
considered
clause.
retrospective and
No, the entries in the clause itself we haven't discussed today yet. Is like what is it will fit in this clause which doesn't fit in that is not satisfied, not clear for me yet. That's what I'm saying. In spite of having so much discussion, I still don't know what comes into 7AA, and I would not agree saying that okay, it is
You mean to
mere.
say both? You mean to say both are mutually exclusive content?
Absolutely.
Mutually
1A and
exclusive.
1AA is mutually exclusive, is my view.
How can it be? Because it says activities or transaction. Activities or transaction, can it be independent of forms of supply?
See, now these forms of supply are in a sense exhaustive. In a sense exhaustive because last time in discussion Jatin sir said that even if we're if there are something more than these 8 clauses, it should be subsets of these. Like that is why Jatin sir said assignment doesn't cover in 7.1a because it cannot be subset of any of these 8 clauses. So all these while we were thinking this is not an exhaustive one, such as, because of the word such as, it is only indicative of the types. But after the previous discussion, okay, so because it has such as, ejusdem generis does not apply. All that discussions we had, no. So any further aspects which can expand this such as should be subset of these 8. So that we understood. Now the below one, it says activities or transactions. That is a broader terminology to include and encompass many other things than these 8 things.
What are those things? Probably right now.
Okay, probably one question to let's say if any of this association does an assignment. Just to continue that example, now because assignment does not fit in 7.1a, can we say if assignment happens through 7.1a, just for the sake of hypothetically considering the situation, can we say that that gets covered because 7.1a is broader than 7.1a?
Assignment is an activity. There also
No, assignment of rights. No,
right
assignment of rights.
No,
where only rights are transferred without liabilities.
In my view, activity or transaction means I don't think assignment is covered here. I'm not.
No. I just took a wild example how to distinguish what does not cover in 7.1a. Can it get covered in 7.1a? Because 7.1a is broader comparatively.
But 7.1AA, we only need to know that it is only to by a person to its members.
Correct. Restricted only to that, not to others.
Yeah. And also 7.1b is also an independent section, but we have to read co-jointly. That is another point which I want to bring, that we can't say that they're mutually exclusive means like both are, all are independent. They are connected under the scope of the supply. Connected in each of its own shell, respective.
See, one example I can think of is there are these, cooperative societies which collect funds from the members for procuring land. And then members can change based on the contribution, and finally, at the time of registration, whoever are the members, they will get the registration per se. Now, if we want to extend this example of assignment to this case, since the form of entity is again a cooperative society where mutuality principle also exists, and it can fit in 7.1a, although assignment doesn't get covered in 7.1a, can it get covered in 7.1a because it's a broader one? And also, there could be practically so many scenarios we might not have come across. So, but obviously law has to take care of all possible situations. So maybe just to think out loud. So to distinguish between 7.1a and 7.1a, this is more broader per se.
Yeah, so when he's leaving, probably will formally conclude the session.
Yeah, sure.
Okay. So thank you so much for the opportunity. What I can think of, some kind of facilitation charges. Facilitation, if it does, coordination, facilitation between members and when it comes to redevelopment, will it cover here? 71AA. There's no supply, there's no.
As far as services are concerned, services are quite broad. But then if we can think of some exclusions in 71A, which gets covered under 71AA, maybe we will be able to better appreciate the provision. And also, think of that retrospective and retroactive and conclude on that. We really miss Jatin sir today. It's like, we get
Correct.
struck at some point without answers. Yeah.
Correct. So probably we'll take his help next class when we come, or whenever we get
Yeah,
time.
that's better.
Answer.
That's better.
We'll find an answer for all. Okay.
Yeah, sure.
Thank you so much for.
Thank